The recent U.S. military strikes in Sokoto state, conducted on December 25, 2025, have introduced a volatile new variable into Nigeria's national security landscape. While the strike specifically targeted ISIS Sahel, locally associated with groups like Lakurawa, in response to the alleged persecution of Christians, the fallout has sparked an urgent conversation regarding the safety of the Sokoto Correctional Center. This facility currently holds Nnamdi Kanu, the leader of the indigenous people of Biafra, IPOB, who was sentenced to life imprisonment in November 2025. The intersection of high-profile political detention and international military intervention has created a powder keg scenario that many argue necessitates Kanu's immediate relocation. The primary argument for relocation centers on the fact that Sokoto has now become an active theater for international counter-terrorism operations. With the US launching Tomahawk missiles and precision air strikes within the state, any facility housing a figure as polarizing as Kanu becomes a potential magnet for further chaos. If extremist groups retaliate against the Nigerian state for cooperating with the US, the prison, already a high-value target, could face a jailbreak attempt or collateral damage. For Kanu, whose followers view him as a political prisoner rather than a convict, his continued presence in a combat zone is seen by some as an unnecessary risk to a life that remains central to the fragile peace in the southeast. Beyond the political implications for Kanu, the humanitarian concerns for the broader prison population and the residents of Sokoto are profound. The Sokoto Correctional Center houses approximately 1,300 inmates, most of whom are not high-profile insurgents. Following the Christmas Day strikes, the atmosphere in the state has shifted from one of regional instability to one of direct military engagement. Residents now live under the shadow of potential collateral damage or retaliatory strikes from ISIS-affiliated cells. So, moving Kanu would not only protect him but would also de-escalate the prison's profile, potentially saving the lives of hundreds of other inmates and wardens who are currently caught in the crosshairs of a global conflict. Also, Kanu's legal team had already expressed concerns that Sokoto is too far from his family and legal counsel, making the exercise of his remaining rights difficult. When combined with the new reality of US missiles falling in the state, the call for his transfer to a more stable, less militarized region seems less like a request for special treatment and more like a necessary security protocol. For the Nigerian government, the stakes are high. Allowing a figure of Kanu's influence to remain in a zone of active foreign military bombardment invites a level of instability that the country's current security architecture may not be able to contain. Should the federal government of Nigeria transfer Kanu from Sokoto prison or not, this may become both constitutional and administrative issue. Yes, Rule 59 of the Mandela Rule states that prisoners should be placed to a prison that is close to their homes or places of social rehabilitations. It should be known that this is just a favor and never a right to the prisoners because Constitution of the Federal Republic of Nigeria is superior to Mandela rules. Like the lawyers also claim their accessibility to Kanu at Sokoto prison is becoming difficult, it is a constitutional matter because every prison has a right of access to their legal counsel and distance between the prisoner and location of the legal client do matter if there is certainly no reliable means of transportation or communication that will ensure a smooth accessibility. If the two grounds argued above are not enough to consider relocating Kanu away from Sokoto prison, the fact that every prisoner has right to life and safety, combining with a life-threatening development from Sokoto where the state is being transformed into active war zone may put the government at a tight corner, necessitating relocation of Nnamdi Kanu to a safer correctional facility in the country. Notwithstanding, it is relevant to understand that while a prisoner has right to request a transfer, they do not have an absolute right to where they would be held, and in the case of Nnamdi Kanu, since his ordeal falls under government classification of category of prisoners, even if the call for his relocation is considered, the location of the prison he will be kept will primarily be determined by the government without any or much consideration of his personal preference. Also, the government can rely on state logic that keeping Kanu in a correctional facility located in such a volatile state and far away from his base will help prevent likely attempt of jailbreak by his established miscreants, logically reduce his influence and maintain stability in the southeast where he was charged to have instituted calls for secession. Above all, while the label of Nnamdi Kanu being a convicted secessionist or criminal may diminish public sympathy, the law treats the safety of the individual as a responsibility of the state. If the US strikes have rendered Sokoto a high-risk zone, the argument for relocation shifts from a personal request to a duty of care by the Nigerian government to prevent a national crisis should a high-profile inmate be killed in custody.